Hey everyone, Harry here to talk about the Supreme Court's decision to review a conviction of a January 6th marauder and an issue that may have implications for other of the rioters on January 6th and even potentially Donald Trump. All right, so we're talking about three folks. One, Fisher is the named petitioner, and the issue is they are charged under a statute, 1512C2, with corruptly interfering or impeding an official proceeding. So their conduct, Fisher's conduct is representative. He basically is in there for a couple hours and is just, kicking the shit out of officers or doing whatever he can. He's a rioter and marauder getting swept up in the crowd. And he's charged with many things, including corruptly interfering with an official proceeding. That is the January 6th certification vote. Now, interestingly, both for him and the other two, the case has gone up to the D.C. Circuit on the question whether the statute should cover this conduct, meaning the trial hasn't occurred yet. And normally that's a strong reason for the Supreme Court not to take the case. The Solicitor General for the United States actually said here, look, we don't know everything here. The parties actually disagree on what the facts were. It makes normally that it's in an interlocutory, that means, in between hasn't happened yet. Posture is a reason not to take the case. So that's our first reason not to take it. And yet the Supreme Court did take it. So that's point one. They reached down and took it. Point two is the issue itself. Is it corrupt to, within the meaning of the statute, 1512C2 to do what they did? And in particular, the Court of Appeals that for DC, three judges were kind of all over the map. One judge said, I concur, but only based on this definition of the mens rea element, except the other judge on his supposed side didn't actually employ that decision. And then Judge CATASTROPHIC, the Trump appointee, basically said, look, in order for this to be corrupt, for it to be corrupt, what you need is some intent to basically mess with the evidence or the document. I'm looking now. So importantly, what CATASTROPHIC is saying is in order to corruptly interfere, you've got to tamper with a document, which is the sort of central term in 1512, or have something to do with, messing with evidence and the like. It's not enough to just be a kind of garden variety marauder, as Fisher and these other two were, in order to have liability under the 1512's mens rea, mental intent provision that says corruptly. You're in there sort of fighting in the general fray, in the melee. That's not enough for corruptly trying to impede an official proceeding. We need some kind of tampering with a document or evidence or the like. Okay, that's the issue that's served up. Now, the final point here to emphasize is this is the kind of case that the Supreme Court loves to reverse. So a white collar crime involving some, ambiguity or difficulty of deciphering the mental state, they have more than once struck down either individual cases brought under them or the statutes themselves as being ambiguous. And the fact that they reached out here, when the Solicitor General said, logically enough, just let it go until it brings you get it up here, is an indication that they are spoiling on the issue. And to me, an early indication, in the handicapping of it, that they'll adopt something like the petitioner's view, or more precisely, the view of Judge Katz's below, that it's not enough just to be, in there fighting. You need some kind of tampering with a document. I clerked on the Supreme Court, and had cert petitions that you had to summarize for the whole court. And a total go-to argument was, it's still percolating. Wait till it comes back again. And that's the first thing the Solicitor General said, and they rejected it. So to me, that and the posture of the case, the corruptly mens rea element. Obviously, this isn't a white-collar defendant, but it's the kind of thing, the obstruction statute, that can apply in many different instances. Looks to me like the Supreme Court is very interested in clarifying in a way that throws out the 1512 charge against Fisher and the other two. No great tragedy in and of itself. They're charged with other things. All the conduct that they did do is still an important crime. The question would be, however, whether the corruptly standard under the obstruction would cast a shadow on any of the charges against Trump, and in particular the Mar-a-Lago case, which has a similar kind of charge for his refusal to comply with the subpoena. So that's the sort of subtext of what is at stake here. And as I say, that they reached out for it when they could have waited, and the kind of case it is, I think Supreme Court, watchers who know the court well would say, this has reversal, written, if not all over it. It's you would go in thinking very strong chance that they'll be dubious. They'll be giving the government a hard time, and they'll be very seriously contemplating adopting some kind of construction that would make the charge here go away, and could potentially even cast a shadow on the Trump prosecution. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.